My Lord, I submit he wouldn't necessarily have to discharge the jury, even if, let us say, the individual juror had said, "Oh, I own up. I did try to bribe them." My Lords, it all goes back to the single point. There's a different point that Lord Briggs makes, which is about the introduction of the rest of the jury, but it's just this one point. Supposing the judge is entirely satisfied that 10 jurors can perform their duty properly, I'm sure they're able to do it, but he knows that one is very unlikely to do so. Supposing that is the position, the question is, as a matter of law, must he discharge the jury? That is the question. And if the answer to that is yes, he must, then I accept I'm in difficulties. If the answer is no, he doesn't have to, if the prosecution is content to take the risk that this one juror is just going to vote against the prosecution, come what may, in my submission, he's entitled to do that.
I think the answer that would normally be given is you must discharge that juror.
If of course, I agree with that. In normal circumstances.
So if we assume that the legal position is you must discharge that juror, what is then your submission?
Well, in my submission, if you absolutely must in all circumstances, even in a case such as this, where you've got right to the end of the trial, you can have a 10-1 verdict and so forth. If you must, then my lords, I accept. Then what has happened is that the verdict that was given by 10 people who were entitled to be on the board, the panel, and one person who wasn't. And then the consequence of that would be, I suppose, that you do not have a quorate verdict.
The implication of your submission seems to be that in a criminal trial, and you could hardly have a more serious trial than this, where you have 5 people accused of murder, clearly there's a public interest in a true verdict being returned. The implication of what you're saying seems to be that the judge really has no responsibility in that regard. He's entitled, if the prosecution are willing to run the risk of the jury being nobbled by the corrupt member of the jury, that's a matter for them, and he can go along with that.
My lords, he has to be satisfied that the other 10 won't be nobbled, or it's very unlikely they'll be nobbled. I'd accept that. But if his thinking is, and I submit it was likely to have been this, I've got one bad juror here, I've got good reason to suppose the other 10 will behave properly. That means there will be, the jury will be quorate at 11. In my submission, he is entitled, he is not bound to say, I've got to stop the trial now. He has a power to allow the trial to go ahead. That is, and my lords, I accept that is the kernel of my submission. It has to be one which he exercises not entirely unreasonably in all the circumstances of the case. That is why I'm making the submission as I have been.
If it were the case that the same rules applied in Jamaica as apply in England and Wales, that is, you could have had a jury of 10, what would you then say?
My lord, I think I'd be bound to accept that the judge would have said, let's go down to 10. He probably would, in those circumstances, have said, balancing.
So the problem that you're faced is a system that doesn't allow a jury of 10.
That's exactly the problem. The whole problem.
An unfair trial, it might be put against you, is allowed because the rules don't allow a jury to go around to 10. Is that right?
No. I'm not saying that. I'm far from saying that. As long as the trial is fair, overall, I haven't come to my point about the fairness of the trial, but as long as the judge is satisfied that a fair verdict can be returned, even though one juror appears to be bent on assisting the defence, the judge can say that of the lesser of two evils is that the trial goes ahead, the administration of justice is served by the trial going ahead, and there is no common law rule that requires me to stop the trial.
The corrupt juror might be critical, his vote might be critical to whether there was a majority or not.
It might be. But in those circumstances, that is a risk that the prosecution takes.
Well, that's the point. You see, that's the point I'm jibbing at, really.
Yes.
The idea that responsibility for the administration of justice in the public interest is the responsibility of the prosecutor and can effectively be waived, if you like, by the prosecutor, rather than being the responsibility of the court.
Yes, I do accept that, but my lord, it is still the responsibility of the court. If the court is satisfied...
But we see the problem. If you're presiding in a criminal trial where a majority verdict can be returned, and you know that one of the members of the jury, or you have good reason to suspect that one of the members of the jury may be corrupt, for all you know, the way he votes in the jury room could be critical to the verdict that's returned, and could result in a wrongful acquittal, for example.
My lord, again, I come back to my point. That the judge is entitled to weigh up all the different evils. I mean, the real problem is that the judge was caught between two evil solutions.
Yes, I've got the greatest sympathy for the judge. And I mean, in this country, we would think twice about rerunning a 67-day trial. But in a country like Jamaica, the expense involved in this, apart from anything else, is enormous.
But, my lord, my submission is this: as long as the prosecution is acting responsibly, and as long as the judge is acting responsibly and reasonably, rationally in making these decisions, and as long as they are satisfied that overall there can be, not necessarily that there will be, but there can be a fair verdict, if there can be, then in my submission the lesser of two evils is to go ahead and get that fair verdict, rather than simply say, trial off, no verdict, which in real life may well mean no trial whatsoever. And that is why I say one must look. It's not just a matter of sympathy for the judge, it's what is the responsible, forgive my putting it this way, the responsible response to this very, very difficult situation. Which is the lesser of two evils? And my submission is the lesser is to go ahead in the hope that there can be a fair verdict. You may well land up with an unfair acquittal. That is one risk you take. But it is better to take the chance of getting a fair verdict than to abandon that altogether.
That fair verdict would be reached in circumstances where the allegedly corrupt juror would not only have a vote, but he'd have the opportunity to influence the other members of the jury.
Well, he might still seek to influence the other members of the jury, but he wouldn't. Sorry?
In deliberation. In
deliberation. He can still say what he likes in deliberation. He can still draw attention to a good point, let us say. That can still happen. He's not prevented from doing so. He may well be able to persuade one of the other jurors, not by offering money.
Well, by offering money.
No.
But he may.
No, he may be able to persuade one of the other jurors in deliberation. Look, forget about my bribe. These people are innocent because of point X. He's still entitled to do that.
Well, he's entitled to do that, but he's not entitled to persuade them by offering them bribes.
Certainly
and that is an ongoing risk.
That is, my lady, I accept that is an ongoing risk.
Yeah.
That must be right, is a risk. He will try again.
Yeah.
I mean, you might think it's a bit unlikely if the matter has been reported to the judge, actually, but there's a possible risk. Let us say there's a possible risk. My lady, even in those circumstances, if that is a risk which the prosecution is prepared to take in order to achieve a verdict, that is the lesser of two evils, and if both the judge and the prosecution think that is a proper way of proceeding, they can. That is my fundamental point. And one of the problems with jury trials is one is trying to create a system of perfection, in one sense. Of course this is not perfect. No one would begin to say it's perfect. But is it, in fact, the pragmatic way forward which did, in the event, secure a fair verdict? That is not.
But the defendant's counsel didn't accede to this way of proceeding. That they continued to raise Well, on the face of it, it looks as if they were objecting.
They did. There's no doubt about that. But they were objecting for different. They weren't objecting on the quorum point, but they were objecting because of the way it's put. I think by one of them is the overcompensation point. I'm concerned about it, and that's a fair point.
Yeah.
I'm not saying it's a bad point, but in my submission, it's not a conclusive point. The judge is entitled to say, well, I'm still prepared to put this matter to the jury because of the various points I'm going to come to later, because the strength of the case, I've been assured that I will give another direction. I have already given directions about not being persuaded by extraneous matters. The judge in my submission, and this is in a sense the heart of the case, was he bound to stop it? My answer is no, he was not bound to stop it, for the reasons I've given. And I do submit, I take my Lord's point about the Court of Appeal's judgment, but I do submit this is important to bear in mind what the Court of Appeal had to say about this matter. They have familiarity with how juries work, how the system works, and it's their primary responsibility to ensure the criminal system works properly. You are operating as a second review court. This is a point to me made again and again. And I do submit great respect should be given to the Court of Appeal's assessment on this point.
Well, it will be.
But so, my Lord, you have my point on that. So I say there was no error of law in what the judge did. That's what it boils down to. He acted within his discretion. It was not an unreasonable decision to make, given the extremely difficult circumstances in which he found himself, and the possibility there could still be a fair verdict. That's the point. My Lord, can I just turn to the judge's directions, because it's important, it ties in with the previous point. I've already given you references to some directions before. Can I also ask you to go, please, to E4723 to 4, which is what he says to the jury right at the beginning, which is a resounding direction in my submission. E4723. 4723.
4273 or
4723.
This is right at the start, is it?
Yes, right at the start.
Start of his summing up.
Start of his summing up, yes. And it continues to 4724.
Now, this was, at this stage, by the judge in ignorance of modelling.
Yes. And I don't propose to read that. If you could just read those 2 pages, continuing to the top of 4725. And I should actually ask you to continue to near the foot of 4725, actually. If I may. Now, if I can answer Lord Burroughs' point he put to me yesterday about more pointed summings up in other cases, if this had followed the incident about the bribing juror, one would say it covers the points. Ignore all prejudice. In particular, each of you, right at the beginning, each of you took an oath or affirmation. You will recall that. This is of great significance. I want you to hold to that. The oath is of great significance, not to be treated lightly. The essence of what you swore to do or affirmed is that you would decide the case based on the evidence, and then repeatedly he goes on later. He says, I've been boring you all the time about my constant reminders, and my lord, they're all over the place. I tell you again, because it was of tremendous importance and remains such. And then 4725, implore you. I implore you because of the oath you took, serious and responsible function that you have. You cannot bring external considerations into it. Now, my submission is this. He doesn't repeat this after the incident, but he said it right at the beginning. And in my submission, one has to act on the premise that the jurors haven't forgotten all about this, especially because it's something he's been, if I may put it colloquially, he's been banging on about all the time, the importance of the oath and the seriousness of the task they're employed on.
Can you remind me how long the summing up lasted?
I think it begins on the 6th of March. You can see that at 4722.
Ends on the 13th.
Yes, I think there are breaks. I have a feeling it may have been 3 days altogether, but I will be corrected if it's 4 days.
Thank you.
I think there may have been, but anyway, we know the gap is ultimately 6th of March to the 13th,
I think so.
which is perhaps the more important point.
Yeah.
But in my submission, they won't have forgotten all this. Can I also, while I'm on this point, at 4738, a little bit further on, is the point about prejudice. And this, 4738 to 4741, he goes on about prejudice. Ignore all prejudice. Just look at the evidence. Don't speculate. And it goes on to 4741. In 4741, halfway down the page. If I can just ask you again to read that yourselves. Particularly the first half of 4741. Again, I implore you not to allow feelings of sympathy or prejudice to influence you, cause you to ground your verdict. There's no room for a verdict which has its genesis in sympathy or prejudice. Your verdict must be arrived at on the basis of the evidence and on that basis alone. All this is coming quite early on in the summing up, but it's absolutely emphatic. And just while I'm on the summing up, 4769 is where the judge gives his direction, or the first of his directions, 4769 to 4770, to keep separate. That is to say, consider each of these cases separate. It's an important direction in the context of this type of case. Now, in my submission, taken in the round, these directions were good enough to ensure that the 10 jurors at least who returned the verdict of guilty did so uninfluenced by the offer, or by the misconduct, rather, of the bribing juror. They would not, in my submission, in the light of this, have said, or been subconsciously influenced against them. These couldn't be firmer. That leads me to my fourth point. Was there, looking at the case as a whole, a real risk that the trial was unfair? It's a slightly different question, but it's a global question. I say no. First, I say...
Just before you go there,
yes, of course.
Could I trouble you just to take us to what was said by the judge immediately after the hearing in chambers? You took us to it yesterday, just in terms of page reference.
Forgive me, my lord.
5149.
I'm very grateful.
Yes.
Now,
5149.
5149.
5149 lines 4 to 13.
Yes, thank you.
Thank you.
This was after the
Immediately after.
immediately
yes,
after
immediately.
the matter had been raised with the judge.
Yeah. So the jury come back in, so to speak, after the half hour when they've been kept waiting. And this is the first thing the judge says.
Sure.
And that's why we say it's obvious to the jury what he's referring to, because they will know what has happened in the previous half hour.
Are you suggesting that's a targeted direction? It might be said against you. He's just repeating what he said right at the start of the trial. He's had a specific allegation made, and all he's done is to repeat what he said to the jury at the start of the trial.
Well, without adding quite a bit of the stuff he did say at the start of the trial, summing up. That is true. My Lord, I fully accept it is not targeted. The question is overall. The overall question is, did the jury, is there a real risk the jury was influenced against the appellants? I submit no. They've got the message from the judge loud and clear all the way through.
Do we see anything in either the judge's appraisal of the problem or in the Court of Appeal's appraisal of the problem of a real weighing of the risk of what I think counsel for the defendants at the time called overcompensation, i.e. a risk that because there had been a widespread attempt to bribe the jury, then the defendants must be guilty?
My Lord, I think it's fair to say there is no... well, the judge himself, obviously, he doesn't, because
he's obviously heard the
split decision. Yes, no, he doesn't. No, he just goes ahead. It's a fairly short. The trouble is, it's all dealt with very quickly. It's
And
a
the Court
short.
of Appeal don't seem to address their minds to that issue.
Not quite clear to what extent that was.
You've shown us at any rate.
One of the problems is in the Court of Appeal, as far as one can tell, that doesn't really appear to be the main thrust of the appeal. The thrust of the appeal was more investigation should be made by the judge. The bias point it was there, but it wasn't, so to speak, centre stage. That's my understanding. And so that, no doubt, is why the matter doesn't receive the attention which now it's been subjected to. But, my Lord, the next question is, if I may, was there a real risk that the trial was unfair? I submit that is the ultimate question. That is to say, unfair by reason of subconscious prejudice, or conscious prejudice against the accused because of the bribes that had been offered, apparently in their interest. I say there is no real risk that the 10 jurors who voted to convict were influenced to do so by their knowledge that bribes had been offered by the miscreant juror. And first of all, can I just make this point? I submit it as more accurate to describe the question as one of prejudice than as one of bias. The reason I say that is this. Bias generally, in general language, arises as a result of an internal disposition which affects a person's whole way of thinking about a case or about a matter. And this, in my submission, is a heightened, and therefore there's a heightened risk that a juror won't comply with his oath. Supposing I'm an absolute out-and-out racist, I believe all black people are useless or bad. You're never going to get rid of that. The problem is you're very likely, it's just me, it's part of me. Or let us say I'm a Chelsea fan and I'm a referee in a Chelsea game. I'm just going to give all those split decisions to Chelsea and so forth. It's just in me. I can't help it. That's, in my submission, bias which is irremediable. But there's, at the other end of the spectrum, there's prejudice which arises as a result of, or potential prejudice, which arises in the mind of a neutral person, or neutral jurors, which comes about as a result of an external event, such as here. Or it could be, let's say in the course of a trial, knowledge of bad character comes out. It's that's the real analogy we have in this case. The jurors have found out something which could weigh against which could cause them to weigh or take things into account against the accused and make him think that he is guilty when otherwise they would not have come to that conclusion. And in my submission, it's that type of case we're dealing with. was what happened something which is likely, or there's a risk that it caused them to come to a conclusion they would not otherwise have come?
Does it make a difference whether it's bias or prejudice?
It may not, but
I can't
the
see
reason
what difference it does make at the moment.
But there are some types of prejudice which are more deep, if I can put it this way, insidious. And that would be racial bias, than, for instance, I'm a neutral person and I've come to find out something in the course of a trial, and it will be easier in my submission for me to forget. And the court can more easily assume that the jury will comply with their oath.
So do we come back to Lord Justice Bingham's, as he then was, test in Putnam, where
Yes.
there's a real risk that, not on this occasion a single juror, but all of the jurors, or one of them, might, as a result of the approach, consciously or unconsciously, have become prejudiced
Yes.
for or against
Yes.
one or more of the defendants?
Yes, that, I accept that as the test. And that, in fact, the way it's put there is prejudice rather than bias. My Lords, I accept that is the test. But, as against that, you have to start from the premise that jurors, you can trust jurors not to be prejudiced and to follow their oath. And I've given you the reference in Bonnet. I won't take you to it now because I'm conscious of time, but also at this point, a similar point arose in the case of Morrison, which you can see at E7560, in particular, in paragraph 19. We refer to this in our case, and then 7565, paragraphs 40 to 41, 42, and 44 to 45.
Sorry,
7565, 40, I think, putting it more simply, 40 to 45. And that was a case where, again, the Court of Appeal said, well, you must trust the jury to perform their oath in accordance with their duty. It's a fundamental tenet. Now,
Mr. Knox, I should let you know that we've now received the correct version of the Jury Act, the version of Section 31 that was enforced then is much simpler, and I think it all makes sense.
I'm sorry it didn't make sense.
Well, it's rather easier to make sense of it.
But I'm grateful, my Lord. I haven't yet seen it, but my Lord, I'm conscious of the time. Can I just I move on to my next point? The first point I'm making is you can trust the jurors. This was a question of prejudice, external prejudice. You can trust the jurors to obey their oath. That's my first point. The second point is this. For the purpose of deciding whether the jurors have complied with their oath, you look at the case as a whole. And especially two things. The overall strength of the case, because that goes to whether they would take any notice at all of the offers of the bribe, and secondly, the actual verdicts they came up with. If I can deal with the second point first, the verdicts. As I mentioned, Shane Williams was acquitted. The evidence against him was less strong. It was simply that he was identified by Chow as one of the men in a video talking about, or appearing to talk about, a killing. The case in which this point is made that you can take into account, or it's a point that matters, is the case of Sander, which is an ECHR case at 7965. I won't take you to it, but it's in the dissenting judgment of Sir Nicholas Bratzer. I think it was 4-3, but he makes the point that the Court of Appeal in England had found it a significant point that there were two Asians, one of whom was acquitted, one of whom was convicted. And that was a significant point in showing that the alleged racial bias didn't actually make much difference, or was unlikely to have made any difference to the jury's thinking. And likewise, I say, by parallel reasoning, here too, the bias, if you've expected the bias at least to be operative, or you would have expected Shane Williams to be convicted as well, but he wasn't. As to the strength of the case, if I can summarise it briefly, just taking one or two passages. Prosecution evidence fell into 5 categories. First, there was Chow's evidence. That is summarised in the Court of Appeal's judgment at 5778 paragraph 9 to 5779 paragraph 12. In short, he goes along with the deceased, he's taken along with the deceased in the car with Campbell at the front, driven along, and then he says, because they're being summoned because the guns have gone missing, and then he witnesses the killing by the 4 appellants at the relevant premises, those premises being owned by Mr. Palmer. After that, he returns and he takes Mr. Palmer to hospital. After that, he is offered, they try to get him, Chow, to leave the country along with them, a few days after. That's the thrust of his evidence. Now, that was obviously evidence subject to a lot of challenge, but the real point about it is it was supported by all the technical evidence. It was supported by the technical evidence, the phone calls and so forth. Well, that was one category. The second category was the deceased's girlfriend's evidence, to the effect that the deceased was never seen after the 16th of August 2011, the inference being he was obviously killed on that day, as Chow said. The third category was the evidence of the police investigations after the killing, and in particular, the entire interior of the house where the killing took place was burnt on the 27th of August, about 2 weeks later. There was a foul odour there on the 29th of August, query what was going on, and then by the 30th of September, the entire rear of the house had been demolished. And that is, you get that at the Court of Appeals judgment 5780, paras 14 to 5781, 17. And the appellants were arrested on the 30th of September 2011, and that's 5781, 18. And the point about the burning of the houses is that this was Palmer's house, and there was no report of any damage being done to the house at all by Palmer, and that was a point that was made to the jury. How come, if he owns the house and it's been damaged or burnt down, or burnt at least, how come he makes no report of it at all? The next category of evidence was Exhibit 14C. That consisted of voice and text messages from Palmer, and they are summarised at E5803 to 5807, and they are also summarised in the SFI at E6135, para 10, to 6136, para 13. If I can just ask you briefly to look at the Court of Appeals summary of that evidence, because it just couldn't be clearer. E5803.
Come on, chat, support the live. Get the live stream to 100 likes. Come on.
A big passage describing Exhibit 14C begins at paragraph 69, and then paragraph 70 describes or summarises the effect of the voice notes. In the original, they're quite difficult to follow because they're all in patois. But you can see if you read 70, paragraph 70 at 5803, on to, if I may ask you just to read yourselves to 5806, the end of 5806, you can see the nature of this evidence. And in particular, you will have seen in passing 5805, paragraph 73. This is Palmer's text a few days after the event. Between me and you, the recipient's not identified, we chop up de boy lizard, that's the deceased's nickname. Fine, fine, and dashing we enough. As long as you live, dem can never find him. Oh, couldn't be clearer. But the whole picture couldn't be clearer. And then we have also from JS2 I'm just going to give you the references. We have the texts between the deceased and his girlfriend, in particular on the 16th of August 2011. They are summarised at E4788 to 4791. And you can also see a shorter summary at in our written case at 6227.
Can you just give those references again?
Of course.
Yep.
4788
Yes, thank you.
4791. And in our case, they're summarised again at 6227, paras 40 to 41. But those texts show without a shadow of doubt that the deceased was on his way to be executed, and he suddenly realised what was going to happen to him. There can't be any doubt about that. There are some texts also from Palmer. They were of no significance, but there were texts from Sean Campbell which, to an extent, were incriminating, which suggested that on the day of the killing, but before the killing, Campbell said, who